Hi, everyone. We're going to go ahead and get started now. Good morning. My name is Liz Seaton. I'm the Interim Executive Director of Justice at Stake, a national organization that works for fair and impartial courts and to increase diversity on the bench. And I'm thrilled that you've joined us here today as we, with our partners, release a report that we wrote. And our partners are the Brennan Center for Justice in New York at New York University and the National Institute on Money and State Politics, whose website is followthemoney.org. This report that we're releasing today is the latest in edition of our joint analysis of state high court judicial races, an election cycle series called The New Politics of Judicial Elections. Except alarmingly, it's not new. We've been tracking this for 15 years, since 2000, and the problems are getting worse. This report is titled Bankrolling the Bench, and that speaks volumes. Thank you so much for being here. I see so many partners and allies and distinguished guests in the room. I'd love to name each and every one of you, and thank you for all you're doing, but I'm just the moderator, and I have a limited amount of time. But Bankrolling the Bench and the in-depth work that's gone into it over a year, I just want to thank everybody on our team from all three organizations who wrote this report. It's the incredible, tireless, relentless labor of love that produces such a quality product. And I'm extremely proud to say that for the first time, we're rolling out this report as an interactive website so that people across the country will be able to get the information they need in a very accessible way. It's really very cool. It looks great. So when we're finished with this event, I hope you go back to your offices and homes and have a look at it yourself. It has all the information that people need about a very large democracy issue that very few people are paying attention to. And also, for those of us who just love to hold those data-rich reports in our hands and flip the pages, a hard copy report is coming too, so stay tuned. So let's get into today's discussion. State courts matter. That's why we're here. Why is that? Because 95% of all cases in this country are filed in state courts. That is more than 100 million cases in front of 30,000 state court judges each year. These judges decide cases on all the issues that we all care about: the environment, education, business matters, corporate accountability, voting rights and civil rights, healthcare, and of course criminal justice issues, and so much more. Bankrolling the bench, an apt name, for in the 2013-2014 election cycle, special interest groups set a record. They spent a whopping 29% of total campaign spending throughout the country in state high court elections. Even states with little or no spending felt the surge. This entire discussion could not be more timely. Justice at Stake and our partners, the Brennan Center, collaborate every day to do real-time election tracking in state court high elections. And here's the news. With Election Day 2015, less than a week away, right now Pennsylvania is experiencing its most expensive state Supreme Court election in history. And when last I saw the numbers, documented spending, not spending we haven't been able to document yet, on both sides of the aisle was over $11 million, and that was 2 days ago. And in this context, I'll notice that Bankrolling the Bench shows that in the 2013-2014 election cycle, in 90% of state election high court seat races, the candidate who raised the most money won. The candidate who raised the most money won, which doesn't sound at all surprising in an election context until you realize we're not talking about the political branches. We're not talking about legislators. We're not talking about governors. And we're talking about judges here. They're charged with being fair and impartial, ruling based on the facts and the law and the Constitution. It's a different role that these individuals play in our democracy and that they're meant to play by design. So let's get started. My role here is moderator. So with us to take you through the substance of this report are its primary authors, our enormously talented colleagues, Scott Graytek from Justice at Stake, and Alicia Bannon from the Brennan Center for Justice. Scott is our policy counsel and research analyst. And Alicia is senior counsel in the Brennan Center's Democracy Program. Scott was the leading author of this year's report, and Alicia, it's incredibly valuable to have people who work on this report year in and year out and can bring experience perspective to it as well, was the leading author of the 2011-2012 edition of the New Politics Report entitled How New Waves of Special Interest Spending Raise the Stakes for High Courts, for Fair Courts. There's There are complete biographies for you on the table out there, but let me just, and that's true for all 4 of our panelists. After Scott and Alicia talk about the report, take you through the substance of it, the next thing that's going to happen is we're going to hear from our 2 commentators, and we're incredibly honored to have with us 2 distinguished jurists, Justice Barbara Jackson from North Carolina and former Chief Justice Randall Shepard from Indiana. Justice Jackson was elected to the North Carolina Court of Appeals in 2004. In 2010, she was elected to the North Carolina Supreme Court, resulting in the first 4-3 majority of female justices in the history of the court. That wasn't verses, it was just, a fact. And her present term continues through 2018. Chief Justice Shepard retired in 2012 from the Indiana Supreme Court. Originally appointed in 1985, he served as Chief Justice beginning in 1987. And if I have my facts right, has the distinction of having been the longest serving member of that court. Yes, he's nodding, so that's good news for me. In full disclosure, Justice Shepard also sits on Justice at Stake's Board of Directors, though he'll be speaking in his individual capacity here today. And we'll save some time for question and answers at the end, so I'm going to turn it over to Scott to start, and I'll keep the time. Thanks very much.
So Justice Shepard has been serving as a jurist longer than I've been around on this planet. So that's news to me. Not to put you on the spot, but that is news to me. I will try to remain humble on that. So my name is Scott Graytek. I'm the Policy Counsel at Justice at Stake. First, as Liz mentioned, we want to thank our partners. We have a terrific partnership with the Brennan Center for Justice in New York. My co-authors, Alicia and Elise, and also with the National Institute on Money and State Politics, our last co-author, Linda Casey. We've been putting out new politics reports since the year 2000. I think this is the 8th edition. We've always been tracking spending behind high court elections. This year we wanted to do something a little bit different. And so we're going behind the money, behind the numbers, to try and connect the spending and all the big dollar elections with the folks who actually have interest in front of our courts. So let's dive into it. This cycle, how much was spent in total? We saw spending in 19 states that totaled more than $34.5 million. You'll see the darker shades of blue represent higher spending. So we've got 8 states where spending was over $1 million. As Liz mentioned, money matters in these races because in contested elections, the campaign was able to raise and spend the most money, won over 90% of the time. So our report, after we crunched the numbers, we came out with 3 key findings. The first is that this cycle, outside spending by special interest groups made up a record percentage of all money spent in elections. I'll unpack that in a minute. The second is that big spenders more and more are running the table. And finally, national organizations, groups that operate in multiple states, continue to target state and this cycle, even a local race. So the first finding about outside spending. Outside spending we define as anything that comes from an individual and organization other than the candidate or their campaign themselves. So take a look at historical spending over time since we've been tracking it since 2001. You'll see the largest block is candidate fundraising. That's always been the largest amount of spending. The darkest color blue is outside spending by interest groups. The lightest color is outside spending by political parties. Note that it stuck around in the teens for much of the 2000s. Here comes Citizens United, shot up to 27% in 2011, 2012. This cycle, it's 29%, almost a third of all spending was outside spending. When you add in political party spending, we get to about 40% of total spending. That's a record high for a non-presidential cycle. That means that almost a majority of all dollars being spent is outside spending, not attributable to the candidates or their campaigns. So what does this look like? Montana had a record-breaking election this last cycle. They had over $1 million spent in their election. 75% of it was outside spending. And that really translated in the ads and the kind of campaign materials we saw. So this is an attack ad against Lawrence Van Dyke. He was the challenger to the incumbent. In some sort of irony or perverse messaging on this, there was so much outside spending that these outside organizations, a group Montanans for Liberty and Justice, made the theme of their attack ads that there was so much outside spending. Second key finding is that big spenders, those who could afford to spend a lot of money on these elections, are really running the table. If this pie is total election spending for this last cycle, the top 10 biggest spenders took up 40% of all spending. That's 10 organizations spending almost half of the money in judicial elections. Not only that, but the campaigns themselves, we found, are backed by wealthy interests. For the first time in this report's history, we wanted to find out what sort, the people who are giving to these campaigns, how much are they giving? And we found that in 15 of 19 states that had spending, so about 3/4 of them, a majority of all campaign contributions were at least $1,000. So take a look at what this looks like. In Alabama, you have 99.6 of all contributions to a judge who ran for office were at least $1,000. What stuck out to me was Michigan. This was the most expensive election we saw this year. It was over $9 million. You had 8 candidates running for 3 seats. They raised $5 million. Of that $5 million, 85% of that came in contributions of at least $1,000. These are folks who have the means to be able to contribute to these campaigns who are funding them. Even more alarmingly is that these folks who give to these campaigns do it because oftentimes they have business in our courts. So you'll see the darkest color here are lawyers and lobbyists who give about 1/3 of all campaign contributions. Another 1/3 is from the business community. So what's this look like in practice? In Ohio, there were 2 sitting justices who were up for re-election in 2014. As election season was going, there was a case that came to the Ohio Supreme Court about hydraulic fracturing or fracking. And it was whether or not local towns and municipalities could regulate fracking. One of the incumbent justices who was running received about $100,000 from individuals and businesses with ties to the natural resource and energy interests. She received about $60,000 from businesses and individuals who were actually involved in the case, who wrote a brief to the Supreme Court convincing them, one way or the other, convincing them to rule for the energy companies. Eventually, the court handed down its decision in February of this last year. It was a closely divided court, 4-3. The court ruled on behalf of the energy companies, giving them a win, and the author of that decision was none other than the justice who had received those contributions. So our last major finding is that national organizations are continuing to target state and now even local races. National groups and their state affiliates spent, from what we know, what we can track, $4.8 million, that's about 14% of total spending. 3 of the top 10 biggest spenders this year were national groups. That's more than we saw in the last 2 cycles. We have every reason to think that their presence is increasing. They're getting more aggressive in these elections. Probably the best example of this past cycle is the Republican State Leadership Committee. It's the RSLC. They spent about $3.4 million across 5 states. In case you're not good with state shadows, that's North Carolina, Illinois, Montana, Tennessee, and Missouri. So the last one, Missouri, let's see what it looks like. There was a local billionaire who supported an initiative to get rid of the income tax in Missouri. In Missouri, all ballot initiatives have to run through Cole County because it's where Jefferson City is. It's where the state capital is. A judge who was assigned the case found that the ballot language was misleading, insufficient, effectively struck it down, didn't make it to the ballot. When she ran for election the next time, the billionaire gave about $300,000. This is a county court race, $300,000 to the national organization, the RSLC. And around the same time, the RSLC gave her opponent $100,000. He was in debt before he got this money and spent the other $200,000 on ads like this.
Meet liberal judge Pat Joyce. Radical environmentalists think Joyce is so groovy, and the lawyers funding her campaign do too. Pat Joyce ruled against farmers and their property rights, so she could side with radical environmentalists. And Joyce's re-election is bankrolled by the same lawyers who profit from the cases she oversees as judge. Pat Joyce. Groovy for them, bad for us.
You would have thought the soundtrack would have been a little more hip than that, but that was pretty all right. So I think that these 3 takeaways tell us pretty strongly that we're reaching a tipping point in judicial elections. On this trajectory, we've got almost a majority of all spending is outside spending, not connected to the candidates. You've got a majority of spending almost from 10 select organizations. Only 10 are accounting for 40% now, could soon be a majority of all spending. And national organizations may continue to take a bigger piece of the spending pie and have increased influence in this space. So I want to end on a statement that Justice Sandra Day O'Connor made here at the Press Club at the release of our 2010 report. She said, "The crisis of confidence in the impartiality of the judiciary is real and growing. Left unaddressed, the perception that justice is for sale will undermine the rule of law that the courts are supposed to uphold." I think that was a very prescient statement. We're seeing the numbers head in that direction. I believe that we are reaching this tipping point. Here's our contact information. Please feel free to contact our Director of Communications or myself with any questions. The web address of the new report is newpoliticsreport.org. We're going to be talking about it throughout the panel. Thanks very much.
Thank you so much for having me, and thank you, Liz and Scott, for doing such a great job giving an overview of this most recent report, Bankrolling the Bench, that the Brennan Center, Justice at Stake, and the National Institute on Money and State Politics have released today. I'm Alicia Bannon, Senior Counsel at the Brennan Center for Justice, and one of the co-authors of this report. As Scott and Liz both noted, we've been writing these reports tracking spending in state Supreme Court races for 15 years now. We've been tracking them, and in that time, we've seen this troubling trend towards heightened politicization of state Supreme Court races. We've seen judicial super PACs. We've seen nasty attack ads. We've seen multi-million-dollar races proliferate in states around the country. I'm going to focus my presentation on three aspects of this politicization that I think were particularly striking in the most recent cycle and that we highlight in this most recent report. The first is the tenor of the races, and one thing that I think is very striking this cycle is how criminal justice themes have really became what so many races around the country really focused on, and that's something new or more extreme than we've seen in other cycles. Another theme is new battlegrounds, particularly in the context of retention elections, a particular kind of election that for many years was actually insulated from a lot of the forces that we had seen play out in states, but now increasingly is showing some of the same patterns that we had already been seeing in states that hold contested elections. And then finally, just building off of what Scott was talking about, I also want to talk a little bit more about who's behind the spending and give one more example of some of the interests and forces that have played out in some of these high spending races that we've seen in 2013 and 14. So to begin with television, television is increasingly how state Supreme Court races are run and how they're won. And historically, most of the ads in Supreme Court races were fairly traditional, judges talking about their backgrounds, experiences, maybe their families. This cycle, we saw a real shift in the themes of these ads towards discussion of criminal justice issues. And that includes both justices and other ads supporting justices touting their records as tough on crime, highlighting particular cases that they may have been involved in, as well as attack ads targeting judges as being soft on crime, and again, highlighting particular cases that they may have been involved in. So we saw a record 56% of all ad spots, so more than half of all ad spots this cycle, discussed criminal justice themes, and more than 80% of all attack ads discussed criminal justice themes. And this really matters. There's a growing body of empirical evidence that, in fact, politicized judicial races, a focus on criminal justice issues in judicial races, actually has an impact on outcomes. So, for example, there are studies that have suggested that judges sentence more harshly in election years. There's a study that ACS sponsored recently that actually looked at television advertisements and found that when there were more television advertisements in a state, that judges were more likely to vote against criminal defendants. So it suggests that this, focus on criminal justice issues may actually be having an impact in ultimate outcomes in cases, really going to the basic integrity of our courts. I wanted to give some sense of what these ads look like, so I'm going to show a couple of examples. They're not all groovy as Scott's ad was. Some of these are actually quite troubling. The first ad I'm going to show is actually coming out of North Carolina, and this was an ad that was sponsored by a PAC, Justice for All North Carolina. They in turn were funded by the Republican State Leadership Committee, which receives substantial donations from business interests, many of which and many of which commonly appear in litigation in the North Carolina Supreme Court.
We want judges to protect us when child molesters sued to stop electronic monitoring of their locations, a law that let us track child molesters near schools, playgrounds, daycare centers. Supreme Court Justice Robin Hudson sided with the predators. Hudson cited a child molester's right to privacy and took the side of the convicted molesters. Justice Robin Hudson, not tough on child molesters, not fair to victims.
Now, just to flag, so one large donor to the Republican State Leadership Committee is Duke Energy. So they have, they commonly appear in lawsuits in North Carolina. So I might ask, what interest does Duke Energy have in a North Carolina Supreme Court decision about electronic monitoring bracelets of sex offenders? The answer is they probably don't have much of an interest in that, and that's something that we see time and again. If you look at who's actually spending money on these criminal justice theme ads, it's usually not groups that have a criminal justice mission. Oftentimes, it's business groups, it's plaintiffs' lawyers groups, it's groups that are concerned most likely with other aspects of the court's decision making, but criminal justice issue is a wedge issue, it's an emotional issue, and that's what's used to, and so that's what they spend money on. I wanted to show another ad. This comes out of the Tennessee Supreme Court, also sponsored by an outside group.
28 states fought against Obamacare, but Tennessee went along with Obama. Why? Liberals control our state Supreme Court. Liberal on crime, liberal on the Obama agenda. Tell the liberal Supreme Court, Obama's agenda's just wrong.
Now, what I think is particularly striking about this ad is that the Tennessee Supreme Court actually never even heard a case about Obamacare, but this was what the ad focused on. But what I really want to highlight is actually the response to this ad. So the justices in Tennessee, as well as their supporters, struck back very hard against this was a retention election, so they were facing an up or down vote. They struck back very hard against this anti-retention campaign. They actually outspent the other side, and they put out ads. I won't show the whole ad just for time purposes, but highlighting themes like this. So they highlighted that these justices upheld nearly 90% of death penalty cases. And so, we see, this is an example of kind of criminal justice themes on the other side, touting sort of tough on crime records of judicial candidates. And, I think this is a troubling trend also. If you were a death row inmate who is going to have an appeal being heard by the Tennessee Supreme Court, and a decision in your case might tip them above or below 90%, you might worry a bit. Are you really going to be getting a fair shake before that court when this is what their campaign is so centrally focused on? The next theme that I wanted to talk about was, as I said, kind of new battlegrounds. I mentioned the Tennessee retention election, and what we've seen in recent years is that these retention elections have become increasingly costly and politicized. So to step back a bit, initially we started to see state Supreme Court races have more money spent. We saw them become more politically charged, et cetera. But retention elections, states where judges were standing for an up or down vote, were typically fairly insulated from that. They, we didn't see a lot of spending. They tended to be fairly sleepy affairs. That really changed in 2010. Most notably in Iowa, 3 justices lost their seat after a $1 million anti-retention campaign. And since then, I think there has been a kind of shift in mores in a number of states where judges have increasingly, in these retention states, been targeted as well. And as you can see here, there's been a huge uptick in spending in these states. Still substantially less than what we see in states with contested elections, but actually a tenfold increase in these recent years as compared to the first decade that we were tracking these numbers. And this matters both because it suggests that there may be new battlegrounds, that while we've been tracking this for 15 years, in fact, in some sense, we're just getting started, that there's a whole set of states that have not seen a lot of spending to date that may be seeing these kinds of attacks in the future. And it's particularly concerning because retention elections have often been a piece of policy reforms that have been put forward in terms of addressing judicial elections. So this trend towards more money in retention elections is quite troubling for that reason as well. The last thing I wanted to just briefly touch on is to give a little more color, as Scott was talking about, to who are the spenders in these elections. Where is this money coming from? Why do people care about state Supreme Courts in the first place? And I think this goes back to what Liz was talking about just how important state courts are. They're making decisions that touch on all different aspects of individuals' lives. They can affect corporations' bottom lines. They can affect the rights of unions, employees, obviously criminal defendants as well. They hear a lot of high stakes cases. And to kind of put a clear point on some of the interests that choose to weigh in on these, I wanted to talk about another retention election in 2014, the retention election in Illinois. The Illinois Supreme Court right now is hearing a very high stakes case involving Philip Morris. It's a lawsuit alleging deceptive marketing of light cigarettes, and involves a trial court verdict of $10.1 billion. And I might note also plaintiffs' attorneys' fees of over $1 billion. So this is a high stakes, high value case. This case has actually been before the Illinois Supreme Court before, and one justice on this case, Justice Carmeier, when it previously heard the case, ruled against the plaintiffs. Fast forward to 2014, Justice Carmeier was standing for a retention election, and in the few weeks leading up to his election, we saw over $3 million poured into this retention race in an ad war. He, at the end, very narrowly held on to his seat. But if you look at who was spending in these elections, it was almost overwhelmingly groups where you could trace a direct interest to this lawsuit. So we saw $2 million go into attack ads against Justice Carmeier. 85% of the amount of the dollar amount that was spent by those groups came from plaintiffs' lawyers or plaintiffs' law firms that were actually bringing that suit. So an overwhelming amount of money was coming from the lawyers who stood to gain over $1 billion if they won this suit. On the other side, you saw close to $1 million in ads coming from the Republican State Leadership Committee. They, in turn, had received $500,000 from Altria, Philip Morris's parent company. Now, I'll note that that Altria has said that they asked the Republican State Leadership Committee that money not be spent on judicial elections. But still, I think looking at the sources of the money, it creates conflicts where nobody looks good. And this, I think, comes to the last thing I just want to highlight, which is, what this means, what this spending actually means more broadly in terms of public confidence in our courts. The Brennan Center and Justice at Stake have done polling on this issue for quite some time. And, 87% of voters think that money is actually impacting judicial outcomes. And more than 9 in 10 think that judges shouldn't be hearing cases when they benefit from substantial spending by people who are appearing before them. So I think what this suggests is that, in terms of public confidence, really the integrity of our courts is at risk. And the thing I'll just end with, and I'm happy to talk more about this in the question and answer period, is, at the same time, states are not helpless. There are steps that we can take to mitigate the influence of money in judicial elections. Things like public financing, things like stronger recusal rules, better disclosure so we know where this money is coming from. There are steps that states can take and I think need to take, because as we've seen over this 15-year period, this is a problem that isn't going away. Thank you.
Great, thanks very much. And so now I'm going to turn over to you, Justice Jackson, to talk a little bit about you've run for office for a seat on the bench, a couple of races, very interesting experience. We talked about a little bit, and let's tell everybody about that. And you're welcome to come up here or stay there. Either one's okay with me.
I'll just stay here then. Be a little bit more conversational. Good morning. I'm Barbara Jackson. I'm from North Carolina. And in 2004, I made my first run for public office, and it was for the North Carolina Court of Appeals, which is our intermediate appellate court. We have one intermediate appellate court in North Carolina with 15 judges. There were 3 seats up that year, and I chose to get into a race where there were 4 people in, so we had a primary. I would say I was probably not a particularly well-known candidate at that time. This was the first year that North Carolina had nonpartisan races with public financing. And I think it was a little hard to explain that concept to the voters and to the people from whom we were fundraising. So I said that I was trying to qualify for public financing, but I was unable to do so. So I ran as a non-public financing candidate. During the election cycle, I raised a total of about $25,000 before the election, and another $3,000 came in afterwards, so a total of about $28,000. My opponent is a very nice man. He currently serves as a senior resident Superior Court judge in Western North Carolina. He's from a prominent political family, and he did qualify for public financing. So it was a bit daunting to run against somebody who had about $200,000 to spend on the campaign, who was able to get television ads when I was unable to do so. I was able to get some yard signs and do one mailing. So it involved a lot of legwork, driving around the state. My parents were very integrally involved in my campaign, and we just had a good family bonding experience. I came in first in the primary in July of that year. We had an off cycle because of redistricting, and then I came in first again in the general election, much to many people's surprise. I attribute that win to a number of factors, one of which was hard work, of course. But in North Carolina, in nonpartisan races, women have done very well. So certainly my being a woman helped in that as well. Ballot position also helped. My last name begins with a J, his began with a T. And then the fact that I have a very common name, Barbara Jackson, also helped. Now, I'll take it, but these are not great reasons to elect somebody to a judgeship. And I also touted my experience. I had been practicing law for 14 years at that point, and my opponent had been practicing law for 8 years. So I put all this information out there, and I had a website, and tried to make myself as available to people as I could. But I do think I have to take into account certain realities that people probably didn't know exactly who they were voting for. I will freely acknowledge that. In 2010, I had some folks approach me about running for the Supreme Court. One of the justices was retiring. I thought that was a good time to run. I had been a law clerk at the Supreme Court when I first got out of law school. I happily qualified for public financing at that point in time, so instead of having $25,000 to spend, I wound up with about $250,000 I could spend on a media campaign, which still isn't a lot in North Carolina. We have, according to what I discovered on the internet, we have 10 media markets. 3 of them are out-of-state markets because of Asheville and northeastern North Carolina. But I think judges, as a practical matter, only try to get into about 7 of the media markets. But with $250,000, that's still pretty cost prohibitive to do a lot of advertising. So we went live with my television ad in right when early voting started. So it was a fairly concise period of time. We weren't able to get into all the markets. We tried to get into the ones where we were going to hit the highest number of folks. But the interesting thing about public financing was that you had to meet your qualifying numbers before the primary. So you had to raise a minimum, I think that year was about $40,000, and the maximum you could raise was $79,000. You could raise $10,000 from out-of-state donors, up to $10,000 from out-of-state donors, but the rest of it had to be raised in contributions that ranged between $10 and $500 from people inside the state of registered voters inside the state of North Carolina. I raised about $69,000. My opponent, who was a far more well-established person, raised the full amount of $79,000. Again, I was running against somebody who was far more well-established. He had been in the legislature. He had been a judge on the Court of Appeals for, he was in his 2nd term. Really nice man. He's now, he's retired from the Court of Appeals, and he's the one of the judges at the Eastern Band of the Cherokee Indians. And one of the things I'll say about both of the races I was in, they were extremely cordial. I liked both of the men that I ran against. I think they like me. We're always, enjoy seeing them at events because we were all in the Court of Appeals. We're at holiday dinners together and bar meetings and everything. And I think a lot of them, they're both fine jurists and very nice men and have nice families and everything. So I'm very happy that we were able to conduct very cordial campaigns. And no outside money, no meaningful outside money came into either of those races. The second race I was in at the Court of Appeals, local parties did about $7,000 that we got rescue funds. Rescue funds were still in place in 2010, and by 2012, those had been knocked out. But in any event, I was fortunate again in 2010 that I won. And again, I do think my name probably helped some in that race. And again, I can't underestimate the power of being a woman. My husband and I were very excited to see that there were more women voting in early voting than men. We thought that that would help me. I can't tell you all the reasons that I won, but I think those things were helpful. I think I also had utilized my dollars better in terms of the amount of television advertising that I did. I had conserved the entire $250,000 that I got in public financing to put into TV ads. And those 15 seconds isn't much time to communicate information. I know the discussion of the substance of the ads is very important. You basically have to do a poll and sort of extract from the poll what's going to appeal to the electorate that fits who you are as a jurist. It's not the most elevated way of communicating with people, but it is what we're kind of stuck with a 15-second spot. I think most of us have websites, though, happily. I know I have one that's certainly got much more rich information on it that people are free to visit. I'll just give you a couple broader points. 2014 was a very interesting time at our court. 4 of our justices were sitting for election. Our senior associate justice ran for chief justice and won, and then 3 justices were running. We had one justice that was appointed in September. He ran to retain that seat. We had one justice that was appointed in 2013, and she was running to keep that seat. And then Justice Robin Hudson, the ad you saw on her, she was running to retain the seat that she had won in 2006. And I can tell you we were all, I think, a little shocked when we saw that ad. If you want to Google her, you'll see that doesn't look a lot like her. It was interesting. She came into the next conference we had and said that her son didn't recognize her in the ad. And I think we were all really troubled by that. When somebody dissents in a satellite-based monitoring case, it's just troubling to see your colleague demonized like that. I think we were encouraged, though, that it didn't work. She pulled in a lot of money fundraising off of that ad, and I think the voters supported her in both the primary. She had a 3-way primary, and then the ad didn't run again because it hadn't been successful in the primary, is what we sort of inferred. I think our takeaway was that negative campaigning didn't seem to appeal to North Carolina voters. I hope it stays that way. I think our judicial elections have generally been pretty collegial. I think everybody has, with a few outliers, most of the folks who are opponents of each other have tended to get along pretty well and been very respectful to each other, which is, I think, a good thing for the judiciary and for the legal community. A couple just interesting notes. One of the colleague, Bob Hunter, who was briefly on the Supreme Court and is now back on the Court of Appeals, he was one of my classmates at Duke in the Judicial Master's Program. And he wrote a thesis on nonpartisan public financed elections, which he has subsequently published in the North Carolina Law Review. Due to nonpartisan publicly financed judicial elections enhance relative judicial independence. And a couple interesting statistics that he cites in there are that in 15 of 19 contested cases where women have been it has been a woman versus a man in a nonpartisan judicial election, women have won. That's since 2004 in North Carolina. I think that's really interesting because we've gone from having, in the late 90s, 1 woman on the Supreme Court to having 3 now. There were 4 until our Chief Justice had to retire last year, and having a majority of women on the Court of Appeals bench. So there's a pretty dramatic change in not a long time. And since 2004, with the public finance and then nonpartisan elections, all incumbent Supreme Court justices have retained their seats. Most recently, our legislature has passed a retention election bill. So the next election in 2016, the Supreme Court justice that's running will have a retention election rather than a contested election. That did not pass for the Court of Appeals. Public financing was done away with in 2014. The 15 judges of the Court of Appeals all wrote a letter to the legislature opposing that. The Supreme Court decided that we would stay out of it since we didn't know if anything would land on our doorstep to review. But the Court of Appeals judges also don't have a retention election. Legislature also decided that even though the races were going to be still be these open contests, that they were going to attach party labels back to the judges. So it's kind of an odd situation because you can have 2 Democrats or 2 Republicans in the general election, but it's not a partisan race. And you can still wind up with the very odd situation that we've confronted in 3 elections since 2004, where you have a multitude of candidates for 1 seat. If a judge retires in North Carolina after the primary, but more than 60 days from the general election, it's an open race. So in 2004, one of the justices retired from the Supreme Court in August. So there were 8 candidates, and the person who was the high vote getter at 23% won the seat. In 2010, the state had moved to an instant runoff situation, and the number 2 vote getter in a field of 13 won the seat. That was so confusing and so roundly unappealing that the instant runoff was repealed, and we went back to a system of the highest vote getter. And in 2014, our chief judge of the appeals court retired in August, and there were 19 people that filed for his seat. So a former judge of the Court of Appeals won that election. He had about 24% of the vote, I think. So that to me is one of the challenging things about nonpartisan races. If you had a partisan race, each party would appoint someone to run for the seat, and you wouldn't have that massive number of people running. I think that gets very confusing for the electorate. That I think has been one of the challenges of moving to nonpartisan races. But I think the electorate generally has been pretty pleased with the nonpartisan selection system. Thank you.
And Justice Shepard, we turn then to you for your thoughts about all of this.
Thanks. Well, I'm still absorbing what my comrade has described. Even the office holders have a hard time keeping straight how the system works at any given moment. So bless you. I'll start by talking about something mentioned by Justice Jackson briefly, and that is what is the impact of all of this on the American experiment in self-government? The amount of money, the number of contests, and so on continue to rise, but it's also true that in a great many places, the contending forces spend huge amounts of money to no effect. That is, a lot of money is raised on both sides, and you end up with the incumbent being retained or the incumbent being reelected, and so you would, it seems to me, be led to ask, where's the beef? What is the difference in the end? And it's plain to me that there is one. It is impact on the rule of law. You'll remember that when Alan Greenspan retired, he was asked what explained the long-term health and prosperity of America, and there were a lot of good answers to that. He could have said the world's greatest and first common market. As an economist, that would have been a good answer, but and there are several other respectable ones. Compulsory public education in the 19th century would have been a good one. But not so. He said it's an American adherence to the rule of law, because he believed that it made so many other things about the country work well. And courts and lawyers are sort of at the heart of whether that's actually a promise that we make good on, so that people can have some belief that in the end we're better off with disputes being resolved with a maximum of reason and a minimum of force. The activities we're describing today detract from all that because even the winners, that is to say the people I started out mentioning, even the winners end up so tarnished and beaten up that they are not in a position to evoke from the public the same level of confidence. And a lot of this has to do with the nature of the commercials, which sometimes focus on what's really being debated, as in the Iowa retention election, where the central question was, do we really want, Iowa voters had to decide, do I want to vote to retain judges who decided that gay marriage should be the rule or not? And they decided that they didn't. So there are a few cases where the visible question and the real question line up in the same way. But as Alicia has said, in this cycle, you get even more dramatic shift in the more common situation, which is that the apparent public issue and the actual issue are almost completely divorced. And this focus on criminal law outcomes higher and higher and higher sort of is the prime exhibit of that situation. There have been elections where criminal law has been the actual and apparent issue. The retention election in Nebraska was such a case where the Nebraska Supreme Court had set aside some convictions, and so the actual public issue was criminal law. But most of the time, it's not. It's there because it's so easy to understand, and it's so easy to write a commercial about. The net result of all this, of course, is that although courts continue to register higher levels of public confidence than other branches of government, that they too have been declining. Their poll-indicated confidence has been declining over time. This year, by the way, the biggest decline is public confidence in the U.S. Supreme Court, but that's a whole different story. But in any event, the decline in public confidence is the product of the phenomenon that this report focuses on. That leads me to a related question about what the elections are about and how they're conducted. Since about 1920, there was a code of ethics pretty much adopted in every state that restrained what judges could do, what they could say. Typical example of this is the ex parte rule. You can't talk to parties outside of court with the other parties not present. But one of the established and widely adopted rules was the rule that if you were a judge who was running for election, you could not make pledges or promises other than the diligent performance of your office. Now, this actually happens occasionally, and people would very occasionally get disciplined for it. There was a Texas race in which a judge said, if you elect me, every single person who's convicted of drunk driving will go to prison. That's my promise to you. Now, the problem with that, of course, is that not every person who's convicted of drunk driving really ought to go to prison. There are cases, and there are cases. There are people who get stopped at .04, and some who get stopped at .34, and some people who are habituals and some people who aren't. And if you're really not doing what we hope judges will do, if you do not differentiate between one case and another. So rules like pledges and promises, rules like a prohibition on judges actually themselves soliciting campaign contributions. Happily, the U.S. Supreme Court has affirmed that. But this is a very mixed picture. It's one of those unusual places where libertarians and progressives have joined hands to attack these rules on First Amendment grounds, and sometimes they win. Republican Party of Minnesota is an example of that. Sometimes they lose, even on the hands of a conservative judge. The Seventh Circuit sustained the new ABA Code of Ethics in an opinion written by Judge Easterbrook. But this reflects on what solutions might be realistic to the phenomenon that we're describing this morning. And I'd say a few words about recusal as a solution. First of all, I would say no federal judge should think that the bell doesn't toll for her as well on this point, but that's on very different grounds. If you had a rule if you had a regime in which you said, we're going to elect judges, it is a democratic republic after all. If you had if you're going to elect judges, and because we've struck down the Pledges and Promises Clause in several federal circuits, then people will take positions, people will vote for them or contribute to them, believing that they will advance those positions. And then when the question comes to court, the judge will say, I'm obliged to disqualify. I am disqualified, actually. What that does is make the election a fraud, right? What you've done is to say, vote for Jones because Jones stands for prison every time for each person convicted of this crime. And then when Smith, the defendant, shows up, Jones says, I can't hear Smith's case because I'm disqualified on the basis of my promise, or I can't hear the case for this set of contributors who voted for me, thinking that that's the kind of court they were going to get as a result. And it seems to me that the election in the end becomes actually, I don't think fraud's too strong a word under those circumstances. So one of the reasons why I sat on the ABA committee that wrote the last set of judicial conduct rules, and one of the things we recognized was that there weren't widespread adoption of the previous code's provisions on recusal, and one of the reasons was the one I've just described. There are other reasons as well. Finally, just a word about retention elections. It is disturbing that the number of disputed retention elections and spending in retention elections has been rising. But underneath this data, there's a little bit of rotation going on. Iowa, for example, where perhaps the most visible contested retention election that resulted in people being thrown out of office occurred, has now returned to a relatively quiet place, contrary to Kansas or Tennessee, which historically were relatively quiet, have become battlegrounds. That has a little to do with the culture of the place, but a lot of it has to do with what happens in Washington, D.C. They do not often get up one morning in Des Moines and say, let's have a judicial food fight this year. I mean, they don't look around at each other at the coffee shop and say, boy, it's been too quiet here in Iowa, let's have a fight. But what does happen is that people who might have an interest in this trot to offices within 2 miles of where we're sitting this morning and say, if we decide to go to war, will you back us? And so a lot of what happens in deciding which states have contests and which ones do not is as much a national problem as it is a state problem. I think I'll stop there so we'll have more time for discussion. Thank you.
Great, thank you. So let me just pose 2 questions here very quickly, and then we'll open it up to your question. Just because for people who are not so familiar with this area, I want to make sure you understand the scope of the problem and also what some of the solutions are that we just literally touched on. And I also just want to clarify one thing I said earlier and make sure that I'm interpreted accurately on this point, which is money in politics is a problem across our election systems. When they play out in judicial elections, which is what we're focused on here today, the price we pay is that nobody knows if we can get a fair day in court. Nobody knows if we can get a fair day in court, and that's at the heart of this problem. And I want to just turn to you first, Scott, and just say, could you talk a little bit about in how many states is this a problem? And what's the alternative? And then Alicia, if you could, you just literally touched on so briefly a quick list of the possible ways to mitigate the effects. So I'm just wondering if you could just say just a little bit more about each of those.
So there are 38 states across the country that have elections in some form for their highest courts. That's either traditional elections, a nonpartisan, a partisan election, or retention elections where the judge runs an up or down, yes or no vote every so many years after being initially elected or appointed. About half of the states in this country use something called merit selection to choose their judges. For folks who don't know what merit selection is, it takes many forms. Almost every state does it differently, but it's essentially where a group of attorneys and citizens, a combination thereof, come together and review candidates based on hard, objective, high-value criteria like quality, knowledge of the law, experience, reputation, integrity, and then this panel will suggest a few of those candidates, typically 3, to typically a governor, who will then make an appointment of 1 judge. There are no elections, and it really takes out a lot of the problems that we see which have evolved associated with judicial elections. Something in North Carolina I would point out, North Carolina had a record-breaking election this year, and it saw all the hallmarks of what can go wrong with judicial elections. Negative advertisements, national organizations spending over $1 million, folks who had interests directly in front of the court as the election was going, as their case was moving up through the court, who made contributions to these candidates. There are plenty of states in this country where if a legislative session is taking place, you can't give campaign contributions to your legislator. For some reason, you could give contributions to a judicial candidate during the election season. And the report details a pretty explicit example of that. So the states that have merit selection, that have changed this, don't see the problems associated with judicial elections. And it's really the only sort of systemic reform that's going to be able to break this cycle of spending.
Thanks. I guess one thing to start with is I do think that there are advantages and disadvantages to all different forms of judicial selection. Merit selection, contested elections, partisan, nonpartisan appointment systems. And, I think one thing that's important for policymakers to think about is in states that do have judicial elections, what are the steps that you can take to mitigate some of the troubling trends that we've been seeing in these cycles that that Scott has so powerfully discussed. And 2 reforms that I'll just briefly expand on would be public financing and stronger judicial recusal rules. Public financing is, I think, a very important reform. It gives candidates the chance to run competitive races without needing to rely on special interest dollars, without needing to do the kind of fundraising that creates some of the conflicts that we've seen and that we document in the report. North Carolina is, I think, a powerful case study of this. It had a public financing system for a decade, a very popular system, very successful, and quite beloved by many of the judges and judicial candidates that had utilized it. 2014 was the first time in a decade that candidates ran without a public financing system. Not surprisingly, fundraising records, were shattered. We saw, a huge amount of fundraising, and who did the money come from? Not surprisingly, it came from lawyers, it came from business interests, it came from many of the people who have skin in the game, who have a stake in how these courts are deciding cases. One of the things that I thought was really striking in North Carolina as well was that so many of the candidates were quite vocal about the burdens of fundraising. These are judges. They don't particularly want to be politicians in robes. And unfortunately, when you don't have a public financing system, what that means is that those fundraising burdens go to judges. And you had a number of justices talk about how they didn't want to be dialing for dollars. They didn't want want to be spending their time, raising money. They wanted to be spending their time, actually doing their jobs, writing decisions, as well as talking to people, doing the aspect of campaigning that actually has some beneficial effects, actually talking with the public, talking about their role as judges. But without public financing, what they had to spend their time doing was, an overwhelming fundraising burden. And so that's one important reform. Unfortunately, it's a reform, as I said, that North Carolina rolled back and no longer has an effect. There are 2 states right now that do have public financing systems, New Mexico and West Virginia, and I hope that that's a reform that will be taken up in other states as well. The other reform I wanted to talk about is judicial recusal, and I think I have a different take on recusal than Justice Shepard does. There's recusal rules for all number of issues. Judges need to step aside from cases when they, have a financial stake in a particular outcome. If they own shares in a business that's appearing before the court, they have to step aside from cases if they have, particular family interests where, their child is appearing before the court, things like that. And, there's a basic norm of due process here where, we don't think judges should be hearing cases where the public could reasonably think that, they may have some bias. And, unfortunately, one thing we know from psychology, and there's a number of studies on this issue, is that, we're not always good at identifying our biases. So somebody can, in perfectly good faith, be hearing a case, but can have biases that are still impacting how they might be approaching that case. And that's part of why we have judicial recusal rules, because we understand that people aren't always very good at identifying their own biases. And I think what we've seen with the surge of spending, and as we've noted, so much of that spending comes from interested parties, comes from parties who are actually appearing before these courts, is that it does create these concerns about, are judges really going to be able to hear these cases without any bias or without the appearance of bias? And, unfortunately, I think most states have not strengthened their rules around judicial recusal in response to the spending trends that we've seen. So for example, as Scott talked about, we've seen a huge surge of outside spending by outside groups. Very few states have any rules at all about when judges need to step aside from cases in the face of independent spending. And I think this is an area where much stronger rules are required to ensure public confidence, as well as to give the judges themselves clearer standards about when they should be, when they can be hearing cases and when they can't.
Great, thank you very much. I have other questions for justices, but let me turn it over to you so we get your questions answered. I want to remind you, as they instructed me before, right here, written down, wait for the mic so it comes to you because we're recording it. And also, please introduce yourself by name and organization, if you would, just to help us out. So, let's start here. You had your hand up first, so I literally have to call on you first. Here comes the mic.
Oh, can I hold it? Okay. It's just, my name's Elaine Middleman. I'm an attorney here, but I'm from Indiana. And I'm glad to hear you say that there's a lot of women justices in North Carolina. I just want to briefly say, I was helping my granddaughter with 4th grade Indiana history, and I saw my law school classmate, Myra Selby, in the Indiana history book as being the first woman on the Supreme Court in Indiana. And I also want to say that I'm very glad that Governor Orr appointed you. So
Thank you.
he's been a huge contributor to Indiana. But if you don't mind talking about Indiana a little bit, I think the diversity has improved since back in the day. And also, if you would be willing to comment about the recent 7th Circuit opinion on the Marion County judicial election process.
Sure. In 1970, the voters of Indiana decided to create merit selection systems for all of the appellate judges. So we shifted over from a 130 years worth of partisan election to merit retention. And the happy fact about that is that the number of people choosing to participate, that is to say the people who go to the polls, how many of them press a lever, yes or no, because these are low visibility questions, that percentage has been rising. And likewise, the percentage of people who vote yes has been rising. I take this to be, if not actual endorsement, at least a level of comfort with how this system works. We likewise have in the most urban counties a variety of other systems. Some of those are merit retention systems, and some of them are nonpartisan elections. And we've only had one or two big league fights in those urban situations, and I would have to say in those cases, those were probably fights worth having. Our friend refers to a decision by the Seventh Circuit that the system for trial judges in Indianapolis violates the Constitution. It I hope is the only place in the country where both parties would nominate half the number of judgeships that were in contest, or we're going to say they're in contest, and that unfairly and unconstitutionally limited the ability of people who did not affiliate with a party to participate in the election. There isn't another judge's election in Indianapolis until 2018, so how the legislature will respond to this is yet unknown. I think, actually, as I sit here, I can't remember whether cert's been requested or not. I think it has, but I'm uncertain.
Yes, my name is Joan Claybrook, and I'm President Emeritus of Public Citizen. And one of the things that disturbs me about the remedy of recusal is secrecy of the campaign contributions and the washing or laundering of the money. So that if Philip Morris, in the case that you had, gave its money to the Republican state group, that would be the reported giver of the money and not Philip Morris. And so why is the justice required to recuse himself if he can say, I didn't get any money from Philip Morris? And this is happening all over the place. That's not just that example, but most of the money that's given by big business gets laundered. And so no one knows who's given it, and therefore the justices don't feel that they have an obligation to recuse, and they don't. And how do you remedy that? I think disclosure is a key issue, but how would you suggest remedying this?
Let's work our way down the panel for anybody who wants to address this. Alicia, did you want?
Do you want to go? I'm chomping at the bit. This is it's a great question and a real issue, because as you say, there is a lot of dark money in these judicial races. So, where you don't necessarily know who is spending, the judges themselves don't necessarily know. And I know that that's a concern that some judges have raised is, you talk about strengthening recusal rules, but then we're concerned that we might be in a situation where we didn't actually realize where money was coming from, and we should have recused ourselves, and we didn't, but we legitimately didn't know about the money. I think it does create a lot of uncertainty. I think there's actually a pretty easy. I think there's a fix to this. I mean, there's a need for broader disclosure reform at both the state level and at the federal level. I think, in particular, in the context of judicial recusal, there are steps that courts could take. So for example, in the federal system, if you're a party before the court, you have to file a corporate disclosure statement. So you have to report to the court, and the burden is on you to report to the court essentially information about your corporate structure, so that judges can make determinations about whether they have any conflicts because potential investments in different subsidiaries of the parties appearing before them. I think you could structure a recusal system with procedural reforms similarly done, where you could put the onus on the parties to notify the court about spending that they've undertaken in the context of judicial elections. And that could include money that was given to third-party groups that then spent in those elections. It's not a full panacea. I think there's still, I think there's still money that wouldn't be captured in that system, but I think it would be a very useful, at least first step towards making sure that at least the clearest conflicts where you have parties knowingly spending to influence a judicial election in a way that isn't transparent to the public, that at least that would be captured and then would allow the judge to make an appropriate recusal determination.
You know, one positive story that came out of this election cycle, we talked about Montana earlier. Montana had a record-breaking election, over $1 million. It's the most expensive election they've seen since we've been recording this data. Is that after you have these organizations coming in and spending dark money or secret money, money where we don't know where it comes from, we don't have strong disclosure laws that mandate that anybody who spends money related to an election has to disclose not only their organization but where they get their funding. So Montana came together, bipartisan effort a few months after the election to pass probably the most comprehensible transparency and disclosure law in the country, which now mandates that any organization that wants to spend money related to an election has to disclose their funders. Elections across the board, but folks think that it's a direct response to the ugly campaign that they saw against 75% of all spending was outside spending. With groups with innocuous names of, Montanans for Liberty and Justice. So that is one good result that came from a state recognizing and addressing the problem.
So I'm curious for our justices' views on this.
Well, although I try not to say things like this in my life, I'll say that when I was a lawyer, Scott Graytack's age, I was a lawyer at the Transportation Department where Ms. Claybrook was administrator of NHTSA, and thank you for your service. It's glad to be there with you. I'd like to pose the bigger question about whether, and I'm reminded of it because about the same time I had the occasion, this would be late 60s, early 70s, to be a campaign manager in a federal in a congressional campaign. And at that moment, there were only 3 real PACs in the country. There was the AFL-CIO PAC, there was the Doctors PAC, and there was something I think called BIPAC, which was business and industry. The biggest of those was the Labor PAC, but collectively they were small potatoes. I mean, most of the money that you had to raise in an Indiana congressional campaign, you were going to have to raise from family, friends, and supporters. We decided in '74 that that was a bad idea and that the candidates ought to be separated from this money. And we've been working on that theory ever since. I'd put the question on the table whether that was a wrong. First, I'd put, are we better off now than we were then? I mean, in those days, if W. Clement Stone gave $250,000 to the committee to reelect President Nixon, everybody knew about it. And there weren't other devices, both visible and invisible. And those have been created because of the legal regime that statute and subsequent statutes have put in place at the federal level and by impulse at state levels in many places as well. And I'm not sure we're better off now. I think that that the fact that we knew that Clement Stone had given $250,000 back when that was really big money, okay, still a lot of money, what made it easier to know who was really supporting whom than it is under the regime which has been put in place since. And so I look at judicial races as suffering from this same sort of problem that other races do suffer from, which is that consistent with the Constitution and those statutes, we have made it harder to find out who's really paying the bill. And I'm not convinced that we took the right fork in the road.
Justice.
Can I just comment on the courts? Alicia mentioned the courts could have a rule, as they do in federal system. I'm not familiar with the federal system rule, but that you have to disclose money that you've given that affects any of the judges in the case. Is that what you're saying? Right. And after the Illinois example that you've mentioned, the Philip Morris case, about a year and a half ago, I contacted citizen groups in Illinois to see whether they could try and get the Supreme Court there to enact such a rule. And it's never happened. And my concern is it will never happen. It may be one Chief Justice will stick his neck out or her neck out and do it, but I think it's extremely difficult to get them to do that. And most of the justices don't want it, I don't think. So that's my comment on it. That's why I'm so concerned about it, because recusal really is an empty promise if you don't have public disclosure.
I don't know, Justice Jackson, if you had views on this issue we were talking about, or if I should take another question, I'm not sure.
Yeah, well, I think the thing that one of the things we worry about is when there's an affirmative duty placed on the judge to seek out a lot of information because of our limited resources and ability to do so. And I think that was proposed at one point in the model code, was this affirmative duty to seek out information about recusal. And, you know, I know a lot of the judges that were running in 2014 with the higher dollar amounts being contributed and everything were trying to insulate themselves from their campaign reports. So they had people going over their campaign reports for them, and they were not looking at them to see who had contributed to them because they wanted to have a barrier between themselves and the report as to, you know, so that they would trying to adhere to the duty to hear cases, which is sort of in tandem with the duty to recuse. I think that's sort of the flip side of the coin too, when you've got a 7-member court and you don't really want to have too many recusals as well. So there is a tension there that I think we have to think about as well. But it is, you know, it's an ongoing problem I think we're all going to be grappling with.
We've got about 5 minutes left, so other burning questions back here.
Hi, Pat Murdo, and I am from Montana, so it was great to hear Mr. Graytack say that we have a good disclosure law. I also wanted to point out that, and I'm not an attorney, but as I understand it, the Ninth Circuit Court of Appeals did uphold a disclosure law that pre-existed this one, and the Supreme Court just refused to hear an emergency reappeal of that. So we have had disclosure laws for a long time. Some of them go down to defeat and some of them don't. But my question on the study is, in this last election, the last judicial election for the Supreme Court, there was what I would call a bogus academic research project that Stanford and Dartmouth, you wouldn't think they would be bogus, but they came into the election roughly 2 weeks before the final voting day. So it was already about 4 weeks after early voting had started, and they had just you know, they put the candidates at either end of the political spectrum, basically, and you know, said, does this make a difference to your vote? Well, there was no way to check as to who was responding that way, and there were no controls. And so the question is, have you looked at education as an entrant into the field of influencing political elections? Because this kind of I mean, again, who is funding the research for these two universities, who were requested by our Political Practices Commissioner to issue an apology? They did issue an apology, but I have no idea if the people who were actually planning and carrying out the research, so-called research, ever had any sort of repercussions of it. And so I think that, you know, education often stands as a different, you know, ivory tower, so to speak, and people don't often look at who is funding that type of research in educational institutions, and yet they can have an influence on judicial elections, just like any other kind of money. So have you looked at that?
So I think while those institutions were some of the most, caught a lot of slack in the fair courts community during that period of time. I remember, I think they called it Mailergate going on there. So, you know, I think that really speaks to the fact that when you open these up, when you open up the importance of the judiciary to, you know, elections, that you're allowing folks who, like you said, have no stake in this at all to be able to impact the public and impact public consciousness that is then maybe translated at the polls. You know, it reminds me, the common defense for this often, say the example of Cole County, where a billionaire was able to give $1/3 in a trial court level contest. That goes well beyond any public education purpose, spending $1/3 That's probably outright just trying to buy a seat. So I think that there's a very thin line between educating voters and using that kind of economic concentrated wealth to muscle their way into a position of power.
Do you, Alicia, have something?
Just 1 second, just to give a slightly different tack. I did want to mention another important reform in the context of judicial elections would be the use of judicial performance evaluations. There are some states that have created sort of nonpartisan committees that actually do undertake performance evaluations of judges and then make that information available to the public to allow them to make an assessment of, to have more information. Because, one of the challenges with judicial elections is that they are such low information races and are therefore susceptible to misinformation. There's a lot in terms of how to structure those in a way that avoids, potential biases and the like. There are good ways and bad ways to do judicial performance evaluations, but I think when they're structured well, they can be they're an important reform, an important counterbalance to deceptive information being provided to the public.
With that, I think, folks, we're actually out of time. I'm just going to note that this kind of report takes a lot of people to pull it together. In addition to our two co-authors here, from Kathleen Lisk from the Brennan Center for Justice also was a co-author in this report. Linda Casey from the National Institute on Money and State Politics, and Lori Kinney is editor, as you will see when you look at the book or the website, either one. Please join me in thanking our panelists today for what's been a very interesting discussion. And I think all would be willing to take questions if you have them for them. Come on up and talk to them after our panel here.